Good morning, good afternoon, good evening, whenever and wherever you are. I greet you digitally. My name is Charlie Rose, and this is the Trial Advocate. Today we're going to continue in our journey on a series of presentations that we're doing right now about the 4 pillars of professional responsibility. We're going to move on and take a look at the second pillar of professional responsibility today. We're going to talk about the formation of the lawyer-client relationship. How that relationship gets formed, how it gets nurtured, how it's fed, how the lawyer gets paid, and the types of rights and responsibilities that this creates on the part of both attorneys and clients around the United States. This is an important fundamental block for us as attorneys, because if we don't understand the lawyer-client relationship, we can't properly identify our responsibilities. We can't define the boundaries of what is acceptable for us to do and what is acceptable for the client to require us to do. And we really need to know where those boundaries are, and we need to know where those boundaries are before we're actually engaged in the representation of a client. Because by the time we get to the representation of a client, it's just too doggone late. The opportunity is past for us to properly set and manage expectations, and establishing and managing expectations for the client and identifying the actual goals of the representation are 2 of the most fundamental things we do as lawyers, and quite often we might blow past those in a desire to get the fee, to sign the client, to develop the business. And it's important to us that as we engage in those initial conversations with potential clients, that we really understand the way the rules work, that we've looked at them. This is, of course, one of a block of instructions at the Trial Advocate that we're creating to assist practicing lawyers worldwide and to help law students who are struggling with these concepts and who are trying to develop their own sense of professional identity. It's important that we have a sense of professional identity that resides in each of us, that's unique to each of us. And the rules of professional conduct are useful as far as that goes, because they assist us in laying the foundation of the house in which we're going to practice law. A house built upon a foundation of sand will never stand, and a house that's built upon a rock can stand for a very long time. It's my hope that these presentations become a rock for you in your own professional identity. Let's get started on some of these individual rules. What I'm going to do today are review some rules with you and talk about what they mean, how they apply, and how you might think about them contextually from a practice perspective. You'll notice that Rule 1.1 starts out with the idea that we have to provide competent representation to a client. And that competent representation is defined by legal knowledge, skill, thoroughness, and preparation. And you have to be able to either have it or willing to acquire it, and then you have to be willing to apply it. And the way you determine whether or not you're competent is you have to look at the difficulty and complexity of the legal issues. You have to look at your own baseline of knowledge and experience, and then you compare that to the amount of time that you have available to prepare to adequately represent. And using those factors together, I come to an analysis of whether or not I can get the work done in the time required. This is, of course, a sliding scale. I've been a lawyer for a quarter of a century now. I've practiced in court martials around the world. I've represented clients as both a civilian and as an active duty military officer. And if it's a UCMJ issue, if it's a court martial issue, an administrative issue in the Department of Defense, I can very quickly assess and properly find the right thing to do. In fact, I'm often sorting as we're going through the initial client interview. On the other hand, if you came to me with an employment action and wanted me to assist you in going through the employment process, well, I've done the administrative side of it, but I'd really have to study. I'd really have to work to acquire that baseline of legal knowledge. I've got the skill to represent anybody on anything from the standpoint of standing up and talking and writing. I'm not worried about that. But the knowledge of the substantive law, I'm a trial lawyer, so my knowledge is a mile wide and for the most part an inch deep, except where I've tried cases, and then it's as deep as it needs to be. Well, this rule allows me to take a case and make my knowledge deeper, even if I hadn't previously been involved in that type of litigation or representation. But here's the interesting thing. I can't charge the client for my acquisition of general knowledge. I can only charge the client when I'm doing specific work on the facts of their case. So Rule 1.1 competency and the amount of skill or experience that you have can have an impact on how much you can charge and when you can begin to bill under Rule 1.5, the rule on fees. So it's interesting the way in which these two rules connect together. Rule 1.2 I think of as the rule that says who calls the shots. And what it's really looking at is the objectives of the litigation versus the means of the litigation. And as a general rule, lawyers decide the means, the way in which we're going to proceed. The client decides the objective. And because the client decides the objective, we're in an attorney-client relationship. This is an agency relationship. This is a contractual relationship. My authority to be involved in this legal issue flows from the client that I'm representing. The client has certain rights that you as the lawyer cannot supersede. In a civil case, the client and only the client decides whether or not to settle. That's the client's decision, not the lawyer's. Now, the client can empower the lawyer to decide the case within a range of acceptable outcomes. But if you're going to do that, you need to make certain that that empowerment has occurred before you accept the particular offer in question. In a criminal case, whether or not to plead guilty is the sole decision of the defendant. Now, the defendant should make that decision in all likelihood after consulting competent counsel, but it's their choice. Whether or not to waive a jury trial is completely the choice of the defendant. That right to jury trial is a constitutional right, and it cannot be superseded by the desires of the attorney, by the needs of the attorney. It has to be a decision that's made knowingly, competently, and intelligently. And any waiver of that right must be voluntary for it to be effective. And then a criminal defendant always has the right to testify, to speak the truth as they know it to others. And these areas are not places where the lawyer can prevent the defendant from acting. That has some implications when we get to candor towards the tribunal, because quite frankly, sometimes the client wants to lie to the judge. And you, as an officer of the court, are supposedly not to allow that to happen. We'll save that discussion for when we get to that particular rule, but I want you to think about it now as a kind of a decision point for particularly a criminal defense lawyer. What do I do when the client wants to commit perjury? What do I do when the client tells me they might commit perjury and I don't know what's going to happen? Those are very interesting questions because that juxtaposes Rule 1.2 with Rule 3.3, and that's one of the decision-making nodes that are of importance to trial lawyers. And we'll talk about it when we get to it. But for now, remember, in a civil case, the client always decides whether or not to settle, and in a criminal case, the defendant, the client, always decides whether or not to enter into a guilty plea, whether to waive trial by jury, and whether or not they're going to testify. That's non-negotiable. That's not the lawyer's job to decide. It's merely the lawyer's job to advise. I had a client who was in a great deal of trouble once. We were at the sentencing portion of the trial. He had done some pretty heinous things, which I won't go into here, but I was in the room with him and I was advising him on his right to testify, either under oath or not under oath, to the judge about his misconduct, the expression of remorse. We're looking at trying to reduce his sentence at this point. And he looked at me and he said, "Sir, I don't care anymore." He said, "If you'll give me a 6-pack of Bud, a 5th of Jack Daniels, and a big fatty, you can go in there and tell that judge to put me under the jailhouse." And I looked at the young man and I said, "Sergeant, if you'll write that down, I'll make that argument." Of course, he did not write that down. and I did not make that argument. Part of what we do as counselors is advise clients in difficult situations to help them make clear decisions that are in their best interest based upon what outcome they want to have happen and our knowledge of the law. And in that particular instance, that young man did not need to be disrespectful to the court. But if I'd pushed him on it, he might have very well demanded that opportunity. And instead, by using humor and maybe a slightly veiled threat underneath the surface, I was able to help him see the ludicrous nature of what he was talking about. He was talking from a place of anger, but I'll never forget it. There's a part of me that wishes that he'd given me the authorization to make that argument. If nothing else, it would have been fun to watch the judge's face, right? Rule 1.2 talks about scope of representation when we're dealing with competency and means. And it tells us that as long as we consider paragraph C and paragraph D of the rule, we have to abide by the client's decisions. We have to consult. We have to keep them advised under Rule 1.4. And I've got to tell them how I'm going to accomplish what they've asked me to accomplish. It doesn't go into a black hole where I just do what I want, I wave my magic wand, and like the wizard of the courtroom, we achieve a certain result. I have to let the lawyer know let the client know. Well, unless you're representing a lawyer, then you're letting the lawyer know too, right? By the way, the only client worse than a doctor from a management perspective is another lawyer, just so you know that. You're going to have a great deal of respect for the lawyers who represent lawyers in the very near future. I hope to God that they're not representing you. A lawyer has to keep the client informed of the means you're going to use. You're not required to get their approval for every means that you wish to use, but you want to let the client know how the case is moving, what steps you're taking, and if the client asks, you explain why you're taking that particular step. You're going to discover that some clients want to know everything, and some clients don't want to know anything. They just want the issue to be dealt with. And then you want to remember that just because I'm representing a client doesn't mean that I am the client. I'm not endorsing their political, economic, social, or moral views, and I'm not validating the activities that they may be accused of doing. I'm there to help the client deal with the legal issues and perhaps the social and political fallout and ramifications from those issues, but I'm not the client. And what the client has done, I did not do. And I'm not validating what the client may have been accused of doing by ensuring that their legal rights are protected. The moment we begin to not represent some people because their personal views are odious, or we just think that they're not something I want to be associated with, the moment that we as a profession systemically exclude from representation those who have conducted themselves allegedly in a fashion that most of us find reprehensible, we've just sold our system out. We've just created a set of circumstances where we're no longer self-regulating, and the rule of law doesn't mean anything. It's the rule of the mob. It's the rule of, how many likes or dislikes does that have? It's the idea of instant gratification and that I have to be special in a way that everybody sees on the outside. And that is antithetical to a justice system. And the reason is that if you deny those rights to the worst amongst us, it is only a matter of time before the best amongst us do not have those rights either. We've been down that road in the past. Dealing with it was one of the fundamental reasons that we formed a democracy to begin with. And we can't let that go back to the way it was before and still have the rule of law. Lawyers are literally the folks who stand on the front line from an ensuring of democratic values. And part of that is representing people that no one else will represent. And this rule just reminds us that we are not our client. And what our client does is not what we did. And there's no expectation within the profession that it's the same thing. You need to be aware of that. You need to think about that and see where you fall on that spectrum. Because sometimes the client's views are so disturbing to you that you're not willing to be associated with them because it might create a conflict of interest for you. And Rule 1.2, scope of representation and representing clients that we don't agree with, can sometimes flow into the conflict of interest rule for lawyers' own interests. And I'll give you an example from my own experience. I'm teaching at the Judge Advocate General School. I'm looking for my next assignment, and I was offered an assignment as one of the prosecutors in the military commissions down at Guantanamo Bay. And at the time, I'd been both a prosecutor and a criminal defense lawyer, and I had also taught criminal law, professional responsibility, trial advocacy, and advocates at the Judge Advocate General School for about the last 2.5 years at that point. And I asked the assignment officer if I could have about a day to get some advice and talk to my wife about whether or not I wanted to take that job. So I go home and I call a mentor who had retired from the Army, and I said, "Sir, what do you think? They've asked me if I want to be a prosecutor in the military commissions down in Cuba." And he says, "Charlie, have you read the Korematsu case, the case about the military commissions against the Japanese and the denial of fundamental due process, the denial of some constitutional rights?" I said, "Well, yes, sir, I've read that case." He said, "Do you want your name to be attached to the wrong side of the law in the future so that your grandchildren can read it and know that you were involved in the denial of rights for other folks?" And I said, "Thank you, sir. I get it. Roger. Got it. Out." I go back to the assignment officer the next day, and I say, "Sir, with all due respect, I can't in good conscience participate in the commissions." At the time, the commissions had some rules that actually made them seem fundamentally unconstitutional. And in fact, those rules were later changed because they were unconstitutional. Of course, that's another story. And I said, "Sir, I will volunteer to be one of the defense attorneys down at Guantanamo Bay." And the major looked at me, maybe he was a colonel, I don't remember anymore, I'm getting old. And he said, "There's no way in hell we're letting you get anywhere close to that courtroom if you're one of the defense attorneys." I said, "Roger, got it," and moved on out. In that instance, I had a conflict of interest. I had a personal conflict of interest with my ethical code about what it means to be a lawyer and where I saw the values of the system. And I saw a commission at the time that I thought was fundamentally flawed, that actually violated constitutional law. It just so happens, it turns out that I was right, but I didn't know that at the time. I just knew that that was how I viewed it. And my mentor helped me see that in that set of circumstances, it wasn't right for me to be associated with it. And that's an example of where a conflict of interest kept me from accepting representation. Not because of the views of the client or the political, economic, or social and moral views or activities, because in that instance, I thought that all of it on both sides was perfectly appropriate. I was worried about the fundamental due process that was going to be provided to these individuals, and I didn't want to be part of something that I thought denied another human being the right of habeas corpus, the right to be heard, the right to have the case brought against them. That was a personal legal decision that I made. Lawyers face them all the time in the practice of law. It's going to happen to you. It may have already happened to you. And in those moments, you might want to do what I did. Turn to a mentor, get advice that's covered by confidentiality under Rule 1.6, and then act in accordance with that advice if you think it's in your best interest. So that's Rule 1.2B on representation. If I look at C and D, I can limit the scope of representation. I can say, I'll do this, but I won't do that. I'll do this, and if you then need me to do this next thing, we're going to have to come back and talk about the continuation of the scope of representation. That's where you have a sliding scale of work, a sliding scale of payment, and a sliding scale of duties and responsibilities to the client. And then, of course, we can't have the client engage or assist them in engaging in stuff that we know is criminal or fraudulent. That shouldn't be necessary to have a rule in that fashion, but you see that rule there and you know we have it because somebody did it, right? That's where rules are. Rules are, for the most part, designed to prevent behavior that has already occurred in the past. We cannot have the client engage in criminal activity. We can't assist them in engaging in it, but I can discuss the legal consequences of any proposed course of conduct with the client. And I can help the client make a good faith effort to determine the validity, scope, meaning, or application of the law. So I can work on the edges there. And here is where my requirements under Rule 1.4 to properly communicate with the client and make sure they understand their options runs into my inability to tell them to break the law. How does this work? Let's say I'm a criminal defense lawyer in downtown Orlando. A young man comes bursting through the door with a bag, brown paper bag in his hand. He says, "Can I talk to you?" I said, "Sure, sit down." We go through the initial interview. I take his information. He says, "Look, I'm suspected of having committed a crime. I can pay you in cash. Are you willing to take my case?" And I say, "Sure." And then he opens up the bag. And in the bag is a lot of cash, a gun, and some drugs. And he says, "Can I leave these with you? Can you just put these in your safe? I'll come back and get them later, and your fee will come out of the money that's in the bag." Now, he may just carry cash and guns and drugs around in paper bags. I don't know. But I'm at least concerned that this might be the fruits of a crime, particularly the illegal drugs. So can I take the stuff? Well, yeah, of course I can take the stuff. Can I keep it for him until he wants it back? Theoretically, yes, at least to the guns as to the money. But there's some limitations on it. So I have to tell the young man, "Look, I'm not accepting this from you at this moment in time, and I'm not going to accept it until you and I have a conversation and you understand what my rights and responsibilities are as a lawyer regarding this stuff. If I learn that it is the fruit of a crime, let's say law enforcement comes to me as part of an investigation when I'm representing you and they ask me if I have this stuff in my possession, I'm going to assess it at that point, and I may potentially be required under my rules of professional responsibility to provide it to law enforcement. Now, if I provide it, I'm not going to tell them that I got it from you. I'm not going to in any way say that you came in the door. I'm not going to describe our conversation today. But the actual items in question, I will give to law enforcement if they have a valid legal reason for obtaining it from me. And I won't give it to them until I have to, but I will. I'm not going to hide it for you. I'm not going to make it disappear. And you need to understand that. Now, by the same token, I'm not going to modify what's in this bag in any shape, form, or fashion. I'm not going to wipe the fingerprints off the gun or off the bottle that appears to have drugs in it, and I would never counsel you to do so either. I will keep this in exactly the status and the shape as which you give it to me if you choose to do so. Now, understanding all of that, do you still wish to give me this bag? What have I done? Well, I've advised the client of the potential ramifications if this is discovered. I've told him that I'm not going to hide it for him, that I'm not going to engage in his criminal endeavor. Now, arguably, I might have also informed him or made him think about the potential presence of fingerprints on the gun or the drugs. And maybe he takes it and he wipes it off now, but I haven't told him to do that. And I would never advise him to do that. Now, I could do it in another fashion where I go, "Hey, dude, that gun might have fingerprints on it. Man, that would really screw you over if it's got fingerprints on it. If I take it, it'll have my fingerprints on it too. I'm not touching it. And if I had touched it, I'd be sure to wipe my prints off of it, because that way the cops couldn't tell who it was. Of course, I don't know if there are any fingerprints on it. I haven't touched it, but maybe you have, and perhaps you want to go back and rethink this issue before you give this gun to me." Now what am I doing? I'm trying to tell the client to violate the law. I'm trying to tell the client to destroy evidence. I'm assisting them in engaging in the obstruction of justice, potentially. I'm in trouble as a lawyer. I've crossed a line that I did not need to cross. And you might say, "Well, Charlie, my client's never going to tell anybody that I told him to do that." And I would say to you, sadly, I think you're mistaken. Because the first person that clients, at least in criminal situations, turn to after they're convicted to blame for their conviction is usually the lawyer. And if you've been advising your client to engage in misconduct, and then the client does so, and it doesn't work out the way you promised, you're going to be hoisted on your own petard. You'll be hanging on your own meat hook, my friend. It'll be your fault when they snatch your license. So if we draw these boundaries clearly, we don't have these issues. Rule 1.3 is the diligence issue. Do your job. Be prompt in representing the client. Don't slow play it unless there's a reason, a valid, tactical, or strategic reason to slow play it. And make sure the client knows what you're doing and keep them informed as to what decisions you're making and why. Rule 1.4 is the communication rules. I've got to promptly inform the client of any decision or circumstance that requires their informed consent or that is otherwise required by the rules. Think settling a civil case, right to a jury trial, guilty plea, right to testify in a criminal case. And I've got to consult with the client about the means by which the objectives are to be accomplished. And I keep them informed on the status of the matter. You should be thinking now, Jesus, Professor Rose, Rule 1.1, 1.2, 1.3, and 1.4 all seem to kind of come together and they seem to overlap each other. You, my friend, would be absolutely right. They are and they do. Because they're trying to create this web of responsibilities between you and the client that clearly defines what you do and what you don't do and when you do it. It's why understanding these rules is of importance to us. When folks ask for information under 1.4, I'm supposed to reasonably reply. I have to consult with the client about limitations on my conduct. Think back to the earlier bag, gun, drug example that I gave you. I need to tell that client what the limitations are of what I can or cannot do so that they're not proceeding on a misperception of what lawyers do and what lawyers are capable of and what lawyers will engage in. And this is important pretty much because of the influence of the media over the last 30 years as anything else. There's a perception of lawyers out there now as a hired gun who will do whatever needs to be done to help their side win, regardless of the legal or moral rules that are standing in the way. And that's actually fundamentally, in most instances, not the case. And it's anathema to a self-regulating profession to engage in that sort of thought. I like to win. Man, I like to win a lot. But I don't like to win and have it cost me my reputation. I don't like to win and have it cost me my livelihood. So there is a vested self-interest in playing within the rules from the lawyer's perspective, because you can lose your license, you can lose your reputation, you can lose your livelihood. And there's not any single client that's worth that cost. And you're not required to pay that cost. It's not an expectation of you, and you don't have to engage in it. You can fight hard, you can fight vigorous, but you fight fair. And the system only works when everybody buys into that idea. And you got to explain to your client. The last rule that I really want to talk about in this particular pillar is Rule 1.5, the rule on fees. First of all, remember this. You got to have a fee agreement if I'm going to charge or collect. And I can't have an unreasonable fee or an unreasonable amount of expenses. And when I look at whether a fee is reasonable or unreasonable, there are 6 factors in the model rules and in most jurisdictions. These factors flow, at least to some degree, from Supreme Court jurisprudence. Let's take a look at them. The time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. You may remember our discussion about that from just a few minutes ago. The likelihood, if apparent to the client, that the acceptance of a particular employment will preclude other employment by the lawyer. For example, think the O.J. Simpson trial. Think the Melendez murders. We've had, biopics and these sort of dramas that are really being redone. And in each of those instances, at some point in the movie, money becomes an issue because the lawyer is just not capable of representing anybody else, because these cases consume you ethically, financially, from a timeline perspective. And you've got to be able to paid enough to take care of business, to be able to feed your family. And you're not required to give that up. And so the more difficult the issue, the more complex the issue, the more time that might need to be sunk into the issue, quite often the higher the cost is going to be to the client. You also look at what fee is customarily charged in that particular jurisdiction for similar legal services, the amount involved and the results obtained, although it's not a results-driven business from a pricing perspective, the limitations of time imposed by the client or by the circumstances. How quickly do they want it done? And this goes back to whether or not I can do other work. the nature and length of your professional relationship with the client, the experience, reputation, and ability of the lawyer or lawyers performing the services. Like I said before, I'm a retired Army judge advocate. I've written treatises in military law, treatises in evidentiary law, casebooks on trial advocacy. If you hire me to represent you, I'm going to charge you more than a young lawyer right out of law school, because you get what you pay for sometimes. And there are demands on my time that allow me to charge that rate. As large as that rate is not usurious, as long as it's not beyond the pale, I'm going to be okay. And then we look at whether the fee is fixed or contingent. And fixed and contingent fees are, that's a pretty, shall we say, tumultuous subject. In some jurisdictions, Florida for instance, you've actually got statutes passed by the legislature that put certain reporting requirements and activities on the shoulders of folks who engaged in contingent fee arrangements, but they're actually very necessary and valuable if we're going to have access to the rule of law. Now, I can look at the scope of representation and the basis of the rate, and I've got to tell the client what they're going to be. I have to inform the client. We should do it in writing within a reasonable time after beginning the representation, unless I'm going to charge a regularly represented client on the same basis or rate. So in other words, if it's a long-term client and I have an hourly rate, the client knows what that rate is, I don't have to go into that amount of detail. But if it's a first-time client, or if it hasn't been made clear in the scope of representation, I have a duty to get that done and out of the way quickly, and I have to have a duty to inform of any changes in the fee or expenses. Now, if you'll think about this for a moment, the idea behind this is the client is a consumer of your legal services, and they should be properly informed. And that just makes sense, right? I think we'd all agree that if we were buying it, we would want to know what we were paying for and how much we were paying for. And then 1.5C talks about contingent fees and identifies some that are prohibited by law. If you're viewing this tape because you're studying for a law school exam or the multi-state professional responsibility exam, I would remind you that contingent fees cannot be taken in divorce cases, child custody cases, and in criminal cases. And we've actually got rules that prevent that. And if we're going to have a contingent fee, the agreement has got to be clear so that the client understands what it is they need to do. I can't do it with domestic relations matters or defendants in criminal cases. And I can divide fees with other lawyers, but I got to tell the client that I'm going to do it, and the client does not object to the participation of all the lawyers involved, and the entire fee itself is reasonable. I might require the client to pay some of this stuff in advance. I have to tell the client that it's refundable, a portion of it, if I have an advance payment, if it's not earned. And there's got to be a basis for us, and all unearned fees remain in the lawyer's trust account. Lawyers and fees, well, lawyers and money for the most part, that's a potential area of litigation, is a potential area of professional responsibility, ethical complaints, because quite often the client becomes upset, usually immediately after the litigation is concluded. So we have to know and communicate with specificity and clarity to the client how fees are going to be apportioned, how fees are going to be determined. And we have to keep the client updated, and that communication has to occur. If we do, we should be fine. I want to remind you of the 4 elements of legal malpractice because it's a topic that should probably come up. The existence of attorney-client relationship is check block 1. That the lawyer acted negligently or in breach of contract. That the acts were the proximate cause of the plaintiff's damages, and that but for the lawyer's conduct, the plaintiffs would have been successful in the prosecution of their claim, whether it's medical malpractice claim or wrongful death claim, what it happens to be. You'll notice duty, breach, causation, damages. It's the same approach that you have in negligence cases under tort law, but we focus on the negligence of the lawyer and the scope of representation and proximate cause for the loss of the trial. And I throw those up there just to remind you of them. Some practical considerations. You don't have a duty to accept all cases if you're in private practice. There are some exceptions, and that's when the court appoints you, or by virtue of your position, you have to take the client that comes in the door. And you have a duty to reject representation if it would result in a rule violation or you are not physically or mentally able to engage in the representation. And when I'm thinking about representing a client myself, do I have a conflict of interest? Do I have the competency and resources to handle the matter? Is it a meritorious claim? I try to avoid uncontrollable and unreasonable clients, understanding at the start that all clients are to some extent in a condition of stress because of what they're going through. And then I have to consider my own convictions and my own reputation. And by convictions, I don't mean prior criminal convictions. I mean the things that I believe in case some of you out there were wondering, well, what's he been convicted of? But you have to think about what matters to you, because although you don't take on the values of your client, they are sometimes reflected back on you, quite practically speaking, through the litigation practice. And you've got to be prepared to deal with that as a human being. The moment I begin to talk to a client about potentially representing them, they get the value of confidentiality towards a prospective client, even if I don't subsequently represent them. It attaches when we begin to engage in the conversation about potential representation. Once you become a lawyer, people are always going to want to ask you for legal advice. And you've got to figure out how you're going to do that without giving your legal advice away for free and not running afoul of confidentiality. And there are some practical considerations in establishing lawyer-client relationships. And I think you ought to think about those. You ought to have a process for them. That process should be clearly defined, and you should follow it in your practice of law. Now, guys, in conclusion, I've gone through Rule 1.1, 1.2, 1.4, 1.5. I've talked with you about these baseline rules that sort of set the scene, this pillar of professional responsibility that has to do with acquiring the client, identifying the client's goals, establishing the scope of representation, and then keeping the client informed. This is a bedrock piece of what we do as lawyers. And if we do it effectively and we manage client expectations, we engage in the ethical practice of law, and at the end of the day, we get our clients as close to justice as we can. And that's really what this is all about. Till next time, I'm Charlie Rose, and this is the Trial Advocate.